So thank you so much for having me here today. Today's session is contract laws, and I'm a barrister and solicitor Jagriti Jaswal. I'll be holding your today's session, and I am aware today's session may bring up a lot of questions from you guys, and I would try to answer as many as we can in today's time together. So I'm sure you guys are aware what are contracts, but when it comes to Canada, and if you guys are planning to become a contract lawyer, uh, we have to differentiate. The more we will be bifurcating this subject, it will be more easier for you to understand in pieces rather than you will get a one big topic to understand. So, as per my understanding, first of all, I bifurcated this subject in three pieces. My very first piece is a contract, and the second it comes breach of that contract, and the third comes remedies for that breach. So now we are clear that we have three pieces and we have to go these step by step, and we need to fix everything regarding breaches, and we need to see what remedy going to apply on these contracts. So we're going to further bifurcate every topic so that you guys should understand what contract is. If you guys are practicing contract in Canada, majorly you will be practicing contract combined with property law, because the more you're going to do convincing, the more you're going to become a contract lawyer. It will be clubbed together. How? Because there are lot many contracts are there in a property dealing. When we are buying property, when we are selling property, there are contracts, and their breaches and their validity and their remedies, everything is available there. So why I'm telling you this? So that you guys should start applying this in your today's life. The more you're going to practice this, the more better understanding you guys will develop. Are you guys getting it?
Yes.
And as I always mention, if you want to understand any subject, it is important to go through the syllabus of that particular subject. Once you're going to go through the syllabus, you will understand what NCA wants you to study, and then you can line up your understanding as per the NCA expectations. So this is what I want you to tell, that uh, if you don't have a syllabus, get one at your first availability. At my recommendation and at my reference, just read that syllabus twice. It's very important for you guys to read twice, because one gonna make only 50% clarity what NCA want you to, or what want you to study, or what NCA expect from you to understand during the whole session, or during your journey, right? So once you're gonna read this syllabus second time, you will start linking those topics together. So not wasting much of time on this, I want you guys to give a little idea of this exam. I'm really not sure how it is now, but when we were writing this exam, we used to get 4 to 5 questions. uh, Before us, tender was a very major question, but I haven't seen tender question since last 5 sessions. So I'm not sure if you guys are getting question on a tender or not. But when we were writing this exam, tender was very important topic. So I'm really not sure if you guys had in your exams or not previously. But tender, even if tender is not coming in your exam, it build up a very good understanding for a contract. So we're gonna study tender very importantly, and I want you guys to understand the every term of that particular topic. So I did prepare a PPT for you guys, and I'll walk you through that particular PPT. And let me share that with you guys. Okay, so this is the PPT we have. And we're going to start with the very, very basic understanding of the contract law. So, before I go ahead and explain for you guys what is contract law, anybody from you want to take a stab here? What is contract law? Anyone?
An agreement in which two parties are legally binded to follow the rules and conditions of that particular contract.
Okay, so that is a second requirement of the contract, but there is a requirement which comes previous to this one.
It's like a person makes an offer and the other person accepts it.
Sorry, I didn't get that.
So one person makes an offer and the other one accepts it.
That is there, but not as important as the very first component of the contract. Anyone else? Jatinder, would you like to take a stab here? Hello?
Hello.
Yeah, would you like to try what is contract law?
Uh, Ma'am, basically, I don't have notes yet, so I
Okay,
would like to pass.
you may have some basic understanding. So would you like to try it?
Um, I would like to pass.
Okay. And Gitika, you want to try?
What I understand is like when somebody has an intention that they want to enter into a contract with somebody, like a sale or a purchase, it's like having that intention. Is that what you mean?
There should be some exchange between. So
Yeah.
having an intention comes, I'm like, you may have an intention, but there has to be some exchange of something of some value. That is very, very important. If you are not exchanging something, then there is no legal contract. So there has to be an exchange of something of some value that makes your contract very much legal. And when we say there has to be offer, there has to be acceptance, those are like basic requirements of the contract. But first of all, just to understand, just to grab from your fact pattern whether it is a valid contract or not, first of all you have to see what they are exchanging. Is that of some value? First of all, you need to identify those particular values which they are exchanging and what value they carry. So you need to understand first of all that, and then we come to basic requirements, like it has to be voluntary, there has to be an agreement or promise and meetings of the mind. What we are offering, we need to understand that other person is understanding the same thing. It's not like I'm offering a cup of tea to Rekha, but Rekha is understanding it is a cup of green tea. Right. So there is a very slight difference, but meeting of minds are very important. What I am offering, other person has to understand the same thing. If other person has something different in a mind, that doesn't mean that person agree on this contract. And if there is no agreement, then there is no valid contract. So I have given a very, very easy example for you to understand how meeting of minds work, right? Do you guys understood this, or you want me to quote more examples for your understanding? Hello?
Yeah, I got that. Yeah.
Yeah, you guys can pull up your mic so that you guys can participate, right? It's very important. Your presence is really, really very important for me to understand we are on the same pace or not. Okay. So next it comes to legally competent parties. Now, when we come to legally competent parties, my question to you guys is, can minor enter into a contract or not?
Um, Ma'am, minor cannot enter into a contract. Actually, it is like it is voidable at the option of the party, technically.
So basically, you have to be very specific. if someone says whether minor can enter into a contract or not, yes, minor can enter into a contract, but the contract is not enforceable under the court of law. So any when you guys gonna study for your barrister exams in your family law and a civil law, they're gonna clarify this in a very elaborated manner. Minor, you can do a settlement offer with minor, you can do a contract with minor, but if any kind of disputes happen later times, it is not enforceable under the court of law. So judges will not care about it. They're gonna say, they're gonna see it's a minor. They will not enforce that particular contract, that particular settlement offer. You got it?
Yeah.
So any kind of settlement offer, any kind of contracts done with the minor is not enforceable. But minors have freedom to enter into contract. So it's kind of thing like caveat emptor. It's all your responsibility. If you are entering into a contract with minor, it's completely your responsibility. Then we come to mentally competent. So in our routine life, half of the time we consider 80% of people incompetent, mentally incompetent. But you are considering other person mentally incompetent doesn't make them mentally incompetent, right? So it has to be declared by the court of law or on some medical grounds. So it's not like you guys are saying that particular person is mentally incompetent. That doesn't make that particular person incompetent. It has to be declared by court of law. Let's say if you enter into an agreement with mentally incompetent person, what is the validity of that particular contract?
Now it would be invalid.
Yeah, again, it is not enforceable under the court of law. Okay. And the third basic requirement, the very important legally competent requirement is intoxicated or not intoxicated, right? So let's say, let's quote it this way. Me, I'm selling a property. Rekha is buying a property and deal is finalized. And now we thought, let's celebrate this. And Rekha had 2 glasses of wine, not completely in her senses. And she suddenly signed the documents as discussed and decided. But later on, next morning, Rekha claimed this is not I really want. I don't want to continue this contract and I don't want to buy this property. Is I'm capable to claim this contract? Can I
Ma'am,
claim?
because at that time when I signed the contract, I was in like intoxication, so I was not technically in my senses.
Yeah. So technically, you are not a legally competent here to sign the contract. So the idea is just get it signed before you celebrate, right? Yeah. And then we talk about the legal considerations. So when we talk about a contract, there has to be some legal consideration. Okay, we already studied what are the basic requirements. I don't think it's gonna take more than 5 seconds for you guys to identify from the fact whether everything is falling at the place for the valid contract or not. Because you can, they always, MC always put in a 2 lines fact that it was voluntary or not and whether they promised or not, the parties were legally competent or not. Basically they assume parties are legally competent until unless they specifically mention either of the party was incompetent or either of the party was intoxicated or either of the party was minor. So they're going to specifically mention. If they haven't mentioned anything, that means both the parties are competent. So these are basic requirements of the contract, valid contract. But again, for me, just to make a contract valid, there has to be some legal consideration. What are those legal consideration? How are you going to support your contract with the legal considerations?
Ma'am, in my understanding, it is like the promisor and the promisee. Promisee has to do something in return, or he has to give something which is technically legally binding
Yeah.
on him to do the act.
So when dispute gonna arise and when you guys will be in front of judge, the first thing judge need to see is the legal consideration. And when he is looking at the legal consideration, he gonna see what is exchanged, what is the value, what is the money, what are the damages arised if it is breached. So the very first legal consideration is exchange something of value. Most of the time it's money, right? If it is a sale and purchase of property, then definitely it might be money or maybe another property or something of the value is involved there. So you need to see, you need to figure out what they are exchanging and what value it carry and whether it is valid or not. So it is very important for you guys to identify that what is the legal consideration of the contract. So when you are reading your facts in exam, specify what is the legal consideration on the side of your question, just mention or on a page or a rough sheet, just put a note there that the legal consideration is this property, legal consideration is this money, or whatever you can figure out from the contract. So basically, in our syllabus, they very specifically mention in a first chapter, they have given you the classical theory of contract, like from where this contract is coming and how this get evolved. So if you guys have read your syllabus, you will see in a first paragraph of the chapter 1, they have mentioned this laissez-faire liberalism. So I'm sure you guys haven't paid attention to it because normally we always go for the important topics and we try to practice those important topics, but we always avoid the basic roots of any subject. I understand these are not important, and they will not ask you this in exam, but if you will understand this, it will make a better throughout for you guys for the following topics or following subject, right? So this was a kind of ideology. These includes like variety of concept of classic idea retain great power. Some academic writing still gives impression of the rather stable body of the rules relating to such familiar headlines. So basically, we always talk about, okay, freedom of contract should be there, freedom of contract should be there. I want to ask you guys what you guys understand by the freedom of contract. And please do not tell me the freedom of contract means everybody is free to make any kind of contract. That is not a freedom of contract. So I would like to ask you guys what you guys understand by the term freedom of contract. Let's start with the Rekha. Rekha, you start.
Ma'am, according to me, freedom of contract here, it means that the enforcement of the contract, how legally it is binded.
Okay. Let's ask Majal. Majal, what you understand by the freedom of contract?
Somehow it means that what all clauses and everything can be included in a particular contract which can be considered, like to be binding on both the parties, that should be limited.
Mm-hmm.
So,
And
yeah, in a way, limiting the agreement in particular terms and condition.
okay, let's ask Gitika. Gitika.
I don't know whether it's correct or not, but I think like the contract should be made in such a form that it is accepted, it is enforced, and it is accepted by court. It's not that you cannot just enter into any kind of contract. It should be enforceable legally by the system. Like you cannot go into illegal contracts like somebody's paying money to kill somebody else. That is not in contract. It should be legally enforceable by law.
Okay, and Jatinder, what you think? What is freedom of contract?
Ma'am, I'm blank on this subject
Okay,
right now.
so let's
Yeah.
talk about this. So there are two presumptions when we talk about freedom of contract. One is right, as you guys said, the contract should have important components of the contract, which should be legally enforcement of agreement, which is very much right. Freedom of contract doesn't mean both parties are free to do contract. They are not free to do any kind of contract. There is limit on freedom of contract. The first important is legal enforcement of agreement, and the second is the general presumption is this, but again, legal enforcement of agreement doesn't mean you are free to do any kind of contract. So the the one who wasn't agree with the general presumption of the freedom of contract, they put an idea to put a limits of this idea, like put limit on a contract, freedom of contract. If you have a freedom of contract, that doesn't mean you can contract your kidney. Like you can't sell your kidney. I'm like just like that only. So there has to be some requirement. So what they did is they put it two kinds of limit on a freedom of contract. One regulatory, which is statutory, and one common law. So these are two kinds of limit on contract as well as freedom of contract. So there is a case I have given for you guys. This is Virend versus Alberta. So what happened in this case is he was a guy, and he was appointed by the college. And during his meeting with supervisor or his senior in a college, he mentioned about his bisexual preferences. After a while, college asked for his resignation, and he refused to resign. But later, he was terminated by the college. So when he did a contract with the college, when college appointed him, there wasn't any such thing mentioned, right? That he need to disclose these kind of preferences, or if he has such preferences, he will be terminated. So later on, when he was terminated by the college, he filed a suit against Human Rights Commission on the ground of his employer has discriminated against him because of his sexual orientation. But Commission advised him that he could not make complaint under Individuals' Right Protection Act. So that is not something which is individual's right, because it did not include sexual orientation as protected ground. So what he did is he again had some people who was having the same kind of preferences, and then they filed an appeal under the section 15 of the Canadian Charter Right and Freedom, and that was a landmark case in the history of the Supreme Court. And it later on it was a ground to make these kind of preferences like for I mean like common for everyone. If they have such preferences, that doesn't mean they should be discriminated. So this is no ground for the discrimination. So this is a very important case which we study under the contract law, and which I recommend you guys to read once, because this is where freedom of contract was put on a limit, right? And when we talk about the limit on contract, as I told you, there are two types of limit on a contract. So one is a regulatory. There are statutory as well as other limits on a freedom of contract, some of which are subject of debate. I'm like, of course, in law or in legal prospects, we have so much debates, right? So again, no person shall buy, sell, or otherwise deal indirectly for valuable consideration any tissue for a transplant, or any body or part or parts thereof other than blood or a blood constitute for a therapeutical purpose. So for therapy, for saving someone's life, you can understand. But can you sell your kidney to buy an iPhone? Is that okay? To have such a contract?
No,
No.
that's not justified.
Okay. Would you like to have a little debate by, why? Why you think it's not justified?
Ma'am, because the consideration doesn't count here,
Because
because
it is
this.
contrary to public policy.
Yeah,
It
true.
is contrary to public policy. Yeah, I mean, like everybody have their own personal preferences, but again, if your preference is contrary to public policy, And can you tell me why Viren versus Alberta wasn't a contrary to public policy?
Ma'am, because everybody has their, I mean, preference to
Because
have their orientation.
public
You
in
can't
any way,
be, huh?
because it's not harming public in any way, right?
It's not harming. But then in that event, like just discriminating on the point of orientation, even that is not justified, right? That is public policy, technically.
That is against the public policy, right? Discrimination is
Yeah.
against the public policy. Yeah, that's right.
Yes.
That's very much right. And when we come to common law responses, common law limits on a contract, it comes negligent misrepresentation, breach of duty, vulnerability, undue influence, unconscionability. So you need to. I'm sure you're going to study all these topics in following classes, and you will definitely get a question from negligent misrepresentation, undue influence, or breach of duty. You will always get these three topics in your exam. I'm sure you guys experienced this, right?
Ma'am, actually not. I'm though it was really very like 25 marks, 4 questions. They were very tricky and confusing, frankly
Okay.
speaking.
You want to
And too
discuss
many
how?
things were involved in that. So I don't even remember what I wrote.
So just try to remember that particular thing so that we can polish that criteria or that category of this subject, right?
Yeah.
Okay, so what makes promise enforceable? We always say, okay, right, there is a contract, contracts are enforceable, but when dispute happen and you want contract to get enforced, what two things you want to see?
Consideration
So why consideration is important, now you get to know?
to make it legally enforceable.
Perfect. Why? Because it makes your contract invalid because you can't enforce that later on. So if you are not putting any value to your contract or any value to your exchange, it will be difficult for you to enforce later. So consideration or promise of exchange are two things. When you are telling your examiner that this contract are enforceable, you need to tell why. Why? Because there is a consideration, there is a promise of exchange of this value. This is because of the facts in hand. I can see the consideration and promise of exchange, and in my opinion, this contract is enforceable. So tell your examiner why you are saying that, why you think this is enforceable and valid contract. Or let's see if these two things are missing, consideration and promise of exchange. Then breach of contract has happened. Now what? Now we need to see what are the remedies for that. And when we come to contract, there are two types of remedies. One is award of damages, one is a specific performance. So normally when it comes to specific performance, it always a court always consider injunction. There are two types of injunction: one to enforce function, one to stop function. So it completely depend what court gonna do that. What court will be gonna think that it is justified. Sometimes let's say if me and Jatinder have an contract that I will supply him 200 books, and on the basis of my contract, Jatinder further promised to somebody that he will supply 100 books during this time, and then somehow I breached contract with Jatinder. I won't be able to supply him 200 books in a given time period. So now Jatinder filed a contract suit in a court, and he claimed that the breach of contract has happened, and he had a loss. He had a loss. So what do you think? What kind of damages apply there? What remedy you think is better in this situation?
Like specific performance should be awarded over there because it is affecting another contract what the person has made.
Yes. Why? Because it's not only Jatinder's damage, it is a damage to further parties as well. If he hasn't had a promise to somebody like that, okay, fine, I will deliver 100 books to you, then damages can be considered. Why? Because it's only damages to Jatinder. You got it? But because he further promised to someone, injunction is the better remedy as per me here. Why? Because he is not the one who's getting damages, but if he won't get 200 books, he won't be able to supply 100 books further. You got it? You got it or not?
Yes, ma'am.
Yes,
Perfect.
yes.
Okay, so this is all about your chapter one, like what are the basics of contract. Let's see how better you understood. I'll put a scenario in front of you, and we'll see how better you understood, right? So Jatinder told Rekha that he will deliver almost 500 donuts on Saturday, right? In return to some exchange, let's say he said if Rekha will pay $1,000 to Jatinder, he will be able to deliver 500 donuts to Rekha. Is that a valid contract?
Yeah, ma'am, because there is the consideration involved in this of
And
$1,000.
let's go step by step. Is it voluntary?
Yeah, it's not
Yeah,
forced. Yeah, it is voluntary.
Okay.
yeah,
Is there any agreement between both?
yes. Like
Uh,
Yes.
he will be
But
receiving
there
a
is a no,
consideration.
is there
but
meeting
there is
of
a no acceptance, I guess.
that is later on, but we're gonna see the basic contracts first. Basic requirements. Is that contract? Is
Ma'am,
that a voluntary contract?
it is a voluntary contract and two parties are involved. That is one,
Meeting of
promisor
mind
and
is same.
Yeah, because in return of the donuts, she's going to pay $1,000. So
Perfect.
there is
Uh,
consideration.
so both parties are legally competent.
Yes,
Perfect. Legal consideration is there.
yes,
Okay. Is there any limit on this contract?
yes, because it says by Saturday.
No, no. Limit means freedom of
Like the
contract.
freedom. No, no, I think it's a
How?
valid exchange. It's a
Yeah.
valid
How?
exchange.
Right now maybe he won't deliver the donut, maybe he delivers something else, so then it become a negligent misrepresentation, right? Or maybe he
Right.
deliver some 150, 170, 180. So we don't know. That we'll get to know when he gonna complete his contract.
Yeah.
Make sure this thing, right? Then we come to okay, if Jatinder won't be able to deliver 200 donuts by Saturday, what's gonna happen?
breach
Remedy,
of
like
the
it's a breach
contract.
of contract. Yeah.
And what you think? What's gonna be the remedy?
Damages.
That is right. So you understood the basic concept of the contract. From chapter 2 onwards, your contract law starts. Now you need to pay attention how to do the agreement and what makes agreement valid and how it becomes more um, important, right? So when we talk about formation of agreement, now we need to learn what kind of offers are there, when offer happened, when acceptance happen, and how we consider all these things. So the very first prerequisite of contractual liability based on consent is that the parties must have reached an agreement, same point of agreement, same terms, and same time. Okay, so there is a mirror image rule, which we will discuss, because mirror image rule is everything need to be clear between two. There shouldn't be any hidden facts, any hidden things between two. So it has to be very, very clear between both. And let's talk about offer, right? So if we take the very classic, as per our book or as per our syllabus, the classic law always understand two things: offer and acceptance. But again, it was evolved, and now we need to understand a bit more about the offer. When we talk about offer, um, there are two types of offer. One is a unilateral and one is a bilateral. How many types are offer there?
Unilateral and bilateral, two
Two.
types.
Perfect. So this is very clear. So first of all, you need to figure out from your facts, it is a unilateral contract or whether it is a bilateral contract. Figure out the very first thing from your facts. All terms of proposed exchange, readiness to enter contract, and set out the terms of the contract. The offerer must make a clear, unequivocal statement that he will regard himself as legally bound to perform his promise if the other party accept his promise offer. So this is very general thing. Nothing needed explanation here. So you guys understand that legally bounded party. We already studied in previous slides that legally bounded party should be there, right? When it comes to unilateral contract, no promise is needed. Only performance is needed. Now, let's say I'm sitting here and I say, okay, I have a very important case to file tomorrow, to argue tomorrow, and I need some common law authorities to support my law point. Any one of you can go and figure out the law authorities. The one who will figure out the right authority for me, I'll pay $50 to that person, right? So, what kind of contract is this?
Ma'am, it is based on the
Unilateral.
performance. So
So, it is
unilateral.
unilateral offer because it is open for everyone. I am not having a promise with one particular or two particular people. It is open for anyone, for all. And let's say Majal decided, and Majal start looking for the authority, and she started working on it. So, what she did now?
She has accepted the offer
She
by
put
performance.
Yeah, she put the performance there. And now when she started performance, can I revoke this contract, this offer, sorry?
No.
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 Yeah, because once somebody will start performing, I cannot revoke this contract. And the test applies is a prudent person test, which is a objective. So now there is no promise between me and Majal or between me and anybody, but I just gave a unilateral offer. The one who gonna accept this offer, go ahead, complete the sentence. Through perform.
One who performs
Yeah,
that act
yeah,
is technically accepting that offer.
yes, that is right. So the one who started performance is technically accepting this offer, and now I become legally liable for this offer. Right? Got it? What is unilateral offer? So this is an offer which is open to everybody. There is no value of exchange. I did not said, okay, Gitika, if you will find a right authority for me, I'll pay you $50. I said, whoever. There is no exchange. Nothing is exchange. No promise. It's just if anyone will perform, then we can go ahead and this offer gonna become valid. It's based on the performance. But bilateral example is different. So see, I have put an example here. I will pay you $50 if you bring my guitar from San Francisco. Let's say we are sitting here and we are gathering of 10 people, right? And I openly said, okay, whosoever will bring my guitar from San Francisco, I will pay $500 to that particular person. Do I have a did I exchange any value with one particular person of legal mind or legally competent?
No.
No.
No, it's an open offer which is accepted by performance.
Yeah. Just see, there is no other party who's legally competent, who is doing this voluntary, where minds are meeting. There is nothing such thing, no such thing is happening here. It's just I'm giving an offer, and if other person perform, if let's say if Majal take a flight to San Francisco,
Then she's
then
entering into contract with you.
Yeah,
because
so
she's
she
performing.
performed, she started performance, and that means she accepts this offer. So unilateral offer completes when other party starts performing.
I have a question, Jagriti.
Go.
Now, when you make this offer to public, right? Five people, suppose there are five people.
Mhm.
Now, as soon as Majal starts her, like she starts performing, Rekha also starts performing at the same time. Now,
Okay.
do you enter into unilateral contract with both of them because they both have started the performance?
No, I haven't. I haven't entered into a contract with anybody yet. It's open. Yeah. If I'll say
Like,
this in front of 10 people, maybe five will start performance, and
like
the
they will.
one
So
who
this
will
is my sorry.
complete
This is.
the contract,
Mhm.
he will get. Yeah. Go ahead, please.
So sorry. My question was like as soon as they start performing, acceptance has been done by them, right?
Yes.
But only when the consideration will be exchanged, only
Exchange.
then the contract will be like we have to meet all the elements. It's not
Yeah.
only offer and
Complete.
acceptance.
Yeah.
All of them should be okay.
Very
I
much
got it. Thank
right.
you.
So once she will start performance, and there is a difference between starting a performance and getting a consideration. If she'll get a guitar, then the contract will be completed between us. But once she will start performance, I cannot revoke my offer.
Yep, I got your
Okay,
point. Thank you.
got it? So
Yeah.
the unilateral is very simple. It's you can just identify the key. It's open to all because there is no specific person with whom I'm exchanging any value, right? So tell your examiner whether it is a unilateral or bilateral. When we come to bilateral, it's always very common. Like promise has been now. I promised Rekha that I have a house and I will sell my house to Rekha for $200,000. So which promise is that? What kind of offer is this?
Bilateral because you're making to a specific person.
Making to a specific purpose a person, we have a value of consideration, we have a meeting of mind, we have a legal identity, right?
Yes, right.
Legally competent parties. So everything of a valid contract is here. Promise has been exchanged. I'm selling my house is my value. 200,000 is Rekha's value. So we are exchanging this value with a specific person, specific human being, right? So this is a bilateral promise. Did you guys understood the difference between bilateral and unilateral promise offers?
Yes.
Yes, we did.
Perfect. And then it becomes a very important to understand in contract is termination of offer because NCA always play with it. NCA always wanted to know whether you can terminate an offer or not. An offer can be terminated any time before acceptance. Let's say I said, okay, whosoever gonna find me a right authority, I'll pay $50. And before you guys start any kind of performance, I said, let's not do this. Let's give it up. So can I do that?
Yes, because it is because you didn't start the performance, that means it's not accepted yet.
Yeah. And if the moment I placed an offer and Rekha within a 5 minutes before I said anything, Rekha said, "Okay, let me go ahead and find you right authority. Can I terminate an offer now?"
No, that
No,
cannot be
because I've
revoked.
already started the
No.
performance.
Perfect. So you need to see whether very clear. It's very easy to understand. Very clear whether the performance has been started or not. Whether the other now I said now Jatinder said, okay, Rekha, I'll deliver 200 donuts on Saturday. And Rekha said, okay, fine, and she organized a party for it. What kind of contract it is?
No, ma'am. Can you come again with it? I didn't
Okay,
get that part.
Jatinder said,
Is it
okay.
bilateral?
Yeah, it is a bilateral contract because exchange of promise. Okay, now Rekha accepted Jatinder's offer. Now Rekha said, okay, Jatinder. Jatinder said, okay, Rekha, I don't think I can deliver 200 donuts on Saturday. Can he do that?
No, he cannot
Cannot.
Because it
because
has
acceptance has been done
accepted.
already.
Yeah, because it has been accepted now. So in a unilateral contract, it's always with the performance, and in a bilateral offer, it is always with the acceptance. If other party has accepted the contract, you cannot terminate. And in a unilateral, if other party has started performing, you cannot terminate an offer. You got it?
Yes.
Yes.
Okay. The very next point is revocation is complete when the ability to perform under the offer is lost and the offer is aware of such condition. Offeree is aware of such condition. You got it?
Dickinson, Dickinson versus Dodds.
Hello?
Yes, ma'am.
So when we can revoke, revocation is complete when the ability to perform under the offer is lost. Let's say Jatinder promised to deliver 200 donuts, but somehow he lost that ability. So what's going to happen now? Can he revoke the promise?
Yes, because he doesn't have an ability to do that. So
That
he could have performed it, but when he's not capable enough of doing it, how he will be completing the contract?
Yeah, let's take it this way. Jatinder is a criminal lawyer, and let's say Majal has a criminal suit for him. And he said, okay, sorry, Majal has a civil suit for him. So he said, okay, Majal just called him and told him that she has a legal suit for him and he can pursue with it. Jatinder said yes, but later on he get to know it's not a criminal suit, it's a civil suit. So he doesn't have an ability to perform under the civil suit. So is there any kind of valid contract between them, or is there any kind of revocation available?
Yeah, because he's not competent enough to take civil suits. He can only go through the criminal ones. So this offer can be
He
revoked.
can revoke this offer, right? So when Majal called him and told him like there is a legal suit, and he accepted and he said, "Okay, Majal, come to my office. We can discuss this, right? I can do this for you." Majal offered. Jatinder accepted. Sorry, right. So it's a bilateral contract. Why? Because Majal and Jatinder has some promise exchange. Because Jatinder will get his fees and Majal will get her share of something out of the contract. Like normally in lawyer and client we call it retainer, but retainer is also a contract. But later on, when Majal visited his office, Majal get to know he is not competent enough for the civil suits, the revocation is already there, right? So he can revoke in such a situation where the other person doesn't have ability to perform. Got it?
Yes.
Then
Yes.
the third point is death and insanity. So just remember the keywords before acceptance, ability to perform, death and insanity. Right? And when death and insanity of offerer or offeree happens before acceptance, then what happens?
Death and insanity of an offer or an offeree before acceptance.
Then offer will be terminated because it's not transferable. Let's see. I said, okay, Rekha, I want to buy my house. You can sorry, I want to sell my house. You can buy it for 200,000. And then I before you accepted the offer, I died. So is that a valid offer now, or our offer has been terminated?
Has been terminated.
That
Terminated
that is
because
right. So
because of the
death
death.
and insanity terminates the offer. So just make sure in your mind, just have the keywords before acceptance, ability to perform, death and insanity, and don't get confused with the before acceptance and after acceptance. Before acceptance, death and insanity make offer terminated. Okay, clear? Any doubts?
No.
No, we're
Perfect.
good.
Okay, so moving further, acceptance. Now we know what the offer is. There are two kinds of offer. What is unilateral offer and what is bilateral offer. But how these offers going to be accepted? What is the criteria behind acceptance? So agreement to all terms as proposed to be bound by terms in the offer. Timing is important. Communication of acceptance of offer is very important. So the timing is very important and communication of acceptance is very important. There is always a good saying when it comes to contract acceptance. Let's take it this way. I just proposed an offer that, okay, Gitika, I'm selling my house for 200,000. If you want to buy, let me know. And Gitika accepted. The moment Gitika received my email, Gitika thought it's a good deal. Let me accept this offer. But rather than communicating to me, she start telling to her friends that she's getting a good house or she's having this place or blah blah blah. But I haven't get any communication from her for 2 days, and then and my offer was only for 2 days, but I did not get any communication from her within 2 days. Is that a valid acceptance?
No.
So
No,
Gitika
no,
has to communicate
no.
that I accept your offer. And there is a saying like, okay, Gitika did not. I offered Gitika for 200,000, and I haven't heard anything from Gitika. And I called Gitika, and before she told me that she accepted an offer, I told her, okay, Gitika, this offer has been revoked. Can I do that?
After 2 days, yes, it can be revoked.
No, I'll put the scenario again. I said, okay, Gitika, I have a house. I'm selling my house for 200,000. Let me know in 2 days if you want to purchase this property. Right? And right after 1 day, Gitika, I called Gitika and I said, okay, Gitika, I have to terminate this offer. I'm terminating this offer. Can I do that?
I guess you cannot
Yes, you
because you've
can.
given me a fixed time.
Yes, before acceptance, you anytime you can remove
Yes,
the property.
Yeah.
before
Yeah, yes,
acceptance.
right.
Let's put it this way. I said, okay, Gitika, I'm selling my house for 200,000. Let me know if you want to buy my house. And Gitika is really happy about it. She's getting a very good deal. And she thought, yeah, she's going to buy this house. But after a day, I called Gitika, and on the same time, sorry, after a day, Gitika called me. And but before Gitika communicated me her acceptance, I answered the call and I said, "Oh yeah, it's better you called. I was about to call you to tell you that I'm revoking this contract. Can I do that?"
Yes, you can do it
Yes,
Yeah.
before she says.
because I
So
haven't communicated
contract
you my
lawyers,
acceptance so far.
yeah. So contract lawyers always say, "Don't say hello, just say the acceptance first." Okay, so if you don't want your contract to be revoked, tell other person, communicate with other person at first priority. You need to communicate, and timing is very important. If I say, okay, Gitika, I'm selling my house for 200,000, let me know in 2 days if you want to buy that house. And Geetika wanted to buy that property, but she did not call me within 2 days. After 3 or 4 days, she's calling me and telling me that, yeah, she's interested in an offer. Is that a valid acceptance?
No,
Why?
No.
because of the lapse of time.
Yes. You have to accept the offer within time period. It get
So, Jack,
terminated if you don't accept within time given time period.
if there is no fixed time, then we should
Then
consider
either
reasonable
you
time.
accept it and either other party gonna revoke it.
Okay.
Okay.
Yeah.
So consensus is very important. Conscience is very important. Both parties agree at the same time to the contract. This is what we are saying. Like if there is no time limit, right? And I just offered Gitika, and there is no time for Gitika to accept. It doesn't mean it is a valid contract. They have to agree at the time of the contract. When that contract is happening, both party has to agree at that particular time. And intention. is also very important. You have to tell your examiner every point, intention, certainty of terms. Why intention is important? Intent of parties to be legally bound by the agreement. If you are doing something casually, that means you don't want to be legally bounded by that agreement, right? So intention, make that offer legal, valid in terms of law. Intent of both parties are very, very important to consider that particular offer as legally bounded offer or agreement. Certainty of terms is very important. Vague terms doesn't work in agreement. If I say I'm selling my house for 200,000 and I put some very vague term in a terms and condition, is that a valid contract, valid agreement? It has to be very certain. What are the terms and what are the contract? When you are paying, if I say, okay, Geetika, you can buy my house in 200,000 and let's see when you are paying. No, it has to be, there has to be particular date when this contract is closing, when this contract is completing, when Geetika will transfer this money on what day. So the certainty of the term is very important. You can't have uncertain terms like, okay, Gitika can transfer money whenever she'll have, whenever she feel like. It doesn't work like that. Vague terms and vague conditions doesn't work in legal agreement or a legal contract. Nowadays, before written brackets wasn't that in a classic theory, wasn't that important. I'm like there, but slowly and gradually, like other legal subjects, contract also evolved, and nowadays written records are very, very important for the evidentiary purpose. How are you gonna justify later on whether it was a valid contract, legally bounded contract or not, or whatever, right? So you have to have written record for everything. Then after an offer, you need to know what is invitation to treat, because it is very important to understand offer is the one thing and invitation to treat is another. They are not same. An invitation to treat you can always compare in your today's life. You can always practice this in today's life. Theoretically, there has to be three components, but practically it's very easy. You all go for a shopping, right? You go aisle to aisle. If you like something, you just pick up that particular thing and put it in your basket, and then you go to counter, pay it, and finish the story. But there is a there is a procedure behind it. When you go aisle to aisle, when you see all this stuff there, do you think what it is?
It
It's
is
an
an
invitation to
invitation
Is
to
treat.
there
treat.
in the, I mean, what is there in the display is invitation to treat.
Yeah, they are inviting. Normally, in our running language, we always say, "Oh God, that store is so inviting. It's very inviting store. I don't want to go there. I always overspend there. So it's very inviting store." We always say this, right? So why? Because the things on a display is an invitation to treat. They are inviting you for a treat. Like they want you to pick you. They want the shopkeeper wants you to pick up that stuff and put it on a counter. So once, let's say, Rekha wanna buy a shampoo, and she went to an aisle and she just took this one bottle and asked cashier to bill it. So when she asked cashier to bill it, what she did?
Make an offer.
Make an offer. Now the offer story starts here. Okay, and cashier billed it and gave her a receipt.
She accepted.
Acceptance.
The cashier accepted it
Why? What happened now?
because she billed it and she gave the receipt.
But what happened? What the legal
The
principle of
consideration has been
the
exchanged.
legal principle of contract happened here? Consideration, exchange of value. So now it become
A
a
legal
contract
contract.
between two. And now Rekha didn't like it, and she want to return it. So what is the legal basis to it?
The bill.
Yes. Why? Because that is a legal contract between two.
Yes.
You got it?
Yep.
How invitation to treat work? So everything you see in a display is an invitation to treat. When you decide to pick up that particular car, any kind of stuff, that is a
Offer. You place an offer.
what you guys are doing. You place an, and when cashier bill that, what he do?
Accepted.
Acceptance for a consideration.
Let's say Jitendra want to buy a car. He went to Honda showroom and he just saw a car in an SUV in a display and he said, okay, I want to buy this SUV. What he did,
He made an offer.
he made an offer. Now the manager over there said, he said, I want to buy it for 35,000. Manager over there said, no, sir, it is for 38,000. What he did?
Rejected the offer.
No, he
No,
placed the
that guy
counter.
placed a counter offer instead of the offer,
Yeah,
and that counter offer
it was a
was
counter.
retained by this fellow retained his original price and controlled that the
So
what
he
protected
didn't.
his counter offer. So
Yeah, he did not. Yeah. So what he did is he placed a counter offer. Jatinder said, "Okay, I want to buy this car for 35,000." He said, "No, sir, it is for 38,000." It is a counter offer. So when he said 38,000, do you think Jatinder's offer is still valid?
no counter offer.
No.
I
Yeah,
mean,
no, because
It
counter offer have been
offer
made.
dies when the counter offer is
Yeah.
raised.
So when he placed counter offer, the original offer has been revoked. Now Jatinder said, "Okay, fine, I'll buy this car for 38,000." Now what happened?
He accepted the offer
Accepted.
made by the person.
Perfect. So now you guys understood how invitation to treat journey goes to valid offer, valid contract. So first of all, there was a display of a card that was an invitation of treat. Then he placed an offer. Then there was a counter offer, and then he accepted the offer. You got it?
Yes.
Any doubt so far?
No. We're good.
No.
Perfect. So, what is a test for the invitation to treat? It is again a objective and a prudent person test. So, display with price is an invitation to treat. Customer present at the cash register when he said, "Okay, I want to buy a car for 35,000." That means he placed his offer. And if a manager would have been accepted the offer and sold the car for 35,000, that was an acceptance. But if not, and he plays in counter offer, then there is a counter offer in between. And after acceptance of that counter offer, there will be a valid contract. Got it?
Yes.
So now you guys are clear what are the general considerations, what are the general considerations of contract, what are the legal considerations of the contract, what are the limits on a contract, what is freedom to contract, and what is invitation to treat. Any doubt so far on these topics?
No,
No.
No.
So you guys are good?
Yes.
Yeah.
So.
so far.
Perfect. So, I do have some solved answers for NCA sample exam. I have my own made IREX and notes. Notes, I think I have already forwarded to Majal and Rekha. I'm not sure if I have given to Geetika and Jatinder. Let
No,
me
I
know.
have it.
Okay. So let me know if you guys really want to continue further because further topics are further important topics are like tender. Then contract is not difficult. I won't say contract is difficult. No, it is not. The most difficult part to understand in entire syllabus is first two chapters. If you I'm like, how you guys gonna say negligence is different? It is understandable. it is very common criteria to understand whether misrepresentation was, whether it was a negligently misrepresented or a misrepresentation. It's easily understood, right? Any adult mind can understood whether it is a misrepresentation or not, undue influence or not. All these topics are not difficult. The only difficult part in contract law to understand the basic concepts are first 2 to 3 chapters. If you, and those are difficult, I won't say those are easy. The more you dig into it, the more you get confused. So if you understood the concepts of first 2 to 3 chapters, you are all good in contract, right?
Yeah.
So, as I said, I have solved sample answer for NCA practice questions, and I have my own IREX and notes. Let me know if you guys want to continue further. We're going to continue these classes. And as per contract law syllabus, you guys have 12 topics to cover. And if we want to continue these classes, we need to continue from now onwards, every week one class, because every topic need one class at least for you guys. So with
Yeah,
this,
I am interested. Jagriti, I will be taking these classes.
okay,
Ma'am, even
Same
I'm
here.
interested.
okay.
Just let me know, ma'am, where to pay and like e-transfer or whatever and how much to pay. Just let us know.
Sure.
Yeah.
So it's the same. You guys have my email address. You guys can e-transfer it. And
Mm-hmm.
if we are continuing this class, next class onwards, it will be difficult for you guys. So concentrate completely. And we will be going with the tender, which is very, very important. If you understood the tender, half of the contract principles will be clear. Okay, and because it is a risky subject with high failure rate, I will be after you guys. I won't be any lenient. So that I'm telling you right in the beginning, that and Rekha experienced that when
Me
I
too.
yeah. So I won't be very nice and lenient because I want you guys to pass this exam anyway. Got it?
Yeah.
Perfect. So I'll see you guys next Thursday, same time. And next Thursday onwards, class will be of 2 hours or more, not for this 1 hour. Okay?
Yeah. Sounds good.
Perfect.
All right.
Thank you.
Thank
Then
you
see
so
you
much,
guys on
Jagriti.
next
Thank
Thursday.
you.
Bye.
Perfect. Thank you, Jagriti.